Legal Services are leveling up your legal knowledge on the different areas of law that we practice in. Hello, I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I'll be the moderator of the webinar today. And I do want to thank Kenneth Elliott, our behind-the-scenes producer. Kenneth is our webmaster and IT support specialist here at SC Legal Services. Today, we are joined by SCLS attorney Jon Ozolins, our lead foreclosure attorney. Jon is going to give you some great information about dealing with your mortgage servicer, especially how to get them to give you all of that information that you need or want to figure out what the heck is going on with your mortgage. He'll also be talking about how to get errors corrected when you do find them. I want to remind you the webcast is being recorded, so don't worry about taking a bunch of notes. The recording and the slides that Jon has prepared will be posted on our YouTube channel for SC Legal Services later on this week. Have y'all been there yet? Our YouTube channel at South Carolina Legal Services, we've got all the Level Up Law webcasts on their own playlist there, going back to the day that we first launched the series on June 9th, 2020. We also have an entire series on COVID-19 information on all the areas of law that we practice in on their own playlist. And those of you down in South Carolina hurricane territory, there's a playlist of our disaster series. It's 16 videos about your rights on legal issues that you face before, during, and after a disaster. Okay, here's our disclaimer. Because you know this is general information for the public and not legal advice. We can't give you advice in this type of format. Our presenter cannot answer questions that are specific to your situation, but can give general information that you may find helpful in your situation. You should always consult with an attorney for any specific legal issues that you have. At the conclusion of the presentation, we will provide information on how to apply for the free legal assistance that is available here at South Carolina Legal Services. And finally, today during the webcast, all of the attendees will be in listen-only mode, but please be sure to put any questions you have in the question box, and we definitely invite you to do that. If you have technical difficulties, just put a comment in the chat box, and Kenneth will make the effort to try to help you out with that, but no promises. Sometimes it's on your end. Again, thanks so much for joining us, and Jon Ozolins, our lead foreclosure attorney, take it away.
All right, thank you very much. Today we're going to be talking about dealing with your mortgage servicers, requesting information, and disputing errors. First, a lot of people get a little bit confused about what exactly a mortgage servicer is. Now, the mortgage servicer is the company that handles your mortgage loan account. This is the company that you usually deal with on a day-to-day basis. They collect and process the payments. They manage the escrow account. I think I lost that there. They review borrowers for loss mitigation options. They manage the foreclosure if the borrower is in default. And they are also responsible for responding to qualified written requests. Sometimes this is the owner of the loan, but it doesn't have to be. Mortgage companies often sell the servicing rights to other companies. And servicers will also frequently transfer their loans to other servicers. So a lot of the time when you see those, see the people that are taking your money changing over and over and over, it's not that your loan is being sold, but that the servicing rights are usually transferring from one company to another. It could be either one, so you never know. But the letter you get telling you what's changing should explain that. Now on to the next thing we're going to be talking about today is the Real Estate Settlement Procedures Act, or RESPA. This is a federal law that lays out the procedures and requirements that mortgage servicers have to follow. One of the duties that RESPA places on servicers is the obligation to respond to qualified written requests. That's just a legal term for basically you sending written requests to get answers from them. It can be broken down into two different categories: requests for information and notices of error. We're going to talk about each of those separately in a little bit. But I want to start with a poll now. I'd like to know how many of you have ever sent written requests to or requests for information or notices of error to your mortgage servicer. Kenneth, can you bring up that poll? All right, and we'll give you a little bit of time to process that. And in a few minutes or a little bit, we'll pull up the answers. All right, I think that's been enough time. Do we have the responses? Kenneth, can we get those responses? I'm not seeing them. Is anyone seeing those?
Hey, yeah, John, it says that 0% have done it, 100% have not ever sent written requests. So this is going to be good information for our viewers.
Great, thank you. Not sure why it doesn't pop up on my screen, but it keeps popping me out of slides too. Okay, so what is a qualified written request? This is a tool that the federal government has created for borrowers under RESPA to get answers from their mortgage servicers. An important thing to note is that the servicers cannot charge you fees to respond to these requests. I know a lot of the time they want to because they like to charge you fees for everything, but in this case, it is free. Now this, in order to qualify as a qualified written request, it has to be a written communication from the borrower. It cannot be a verbal request. It has to be made by or it can be made by an authorized representative. It doesn't necessarily have to be that borrower, but you can name someone else who can contact or communicate with them. You have to either request information, assert that there's been an error, or both. And it must include the name of the borrower and sufficient information to identify the loan. You might include things like your property address, account number, last four of your social and date of birth. I would probably stick with account number and property address to make it easier, but as long as they can identify what your loan is, that qualifies. Now, it's important to send it to the right place. If the servicer has designated an address for qualified written requests, requests for information, notices of error, the borrower has to use that address. You want to check your mortgage statement or the servicer's website to find that address. Usually the mortgage statement has it written either on or in a place that says for qualified written requests or something along those lines. This is usually different than the service's regular correspondence address. So you're going to want to look specifically for that. And if you send the qualified written request to the wrong address, the servicer does not have to respond. So be very careful that you send it to the right address. All right, now if you did send it to the right address, there is a timeline for the servicer to respond. They have to acknowledge receipt in writing within 5 days of getting it, and that's business days, so it doesn't count weekends or anything like that. The servicer must send a written request to the written response to your request within 30 business days. Again, that's business days, so that's not just 1 month on the calendar. If the servicer needs additional time to respond, they can send you a written notification that they are electing that they have another 15 days, business days, mind you, of time to answer. So the total amount they can have to respond to you is 45 business days from date of receipt if they need that much time. But you know that they got the request within 5 days, and you'll know within 30 days whether or not they're going to be taking that extra time. Now, if the notice of error is only about an error in the payoff balance, the servicer has to respond within 7 business days instead of 30. Where the request for information is only asking for the name and contact information for the owner of the loan, the servicer only has 10 business days to respond. So those are the special deadlines for very specific requests. But you'll notice that these are only for those things. So if you're mixing those in with other requests, then they're going to use the longer time. I am not sure why it keeps kicking me out of the slideshow. All right. Now we got another poll here. Kenneth, can we bring this one up?
Okay, we have this poll up, and it asks if you have tried to get information from your mortgage servicer by calling them, and gives 5 options for what happened when you did that. Actually, I guess 4 options, and then the 5th option is that you have not tried to call your servicer to get information.
Are you able to see when they or if they've gotten the responses in, or are we just going to give it time and make the call?
Yeah, I can see when the responses come in once he posts them.
All right, so do you just want to let me know when it's up there?
Yeah.
Do we have the responses?
Okay, just got the response. And so as to what happened when folks tried to call, 20% said they got the information they wanted. 20% said they gave up after being on hold too long. 20% couldn't get a clear answer from the servicer. 0% chose that the servicer refused to answer, and 40% have not tried. So basically, 60% of the people who tried, well, 40% gave up or couldn't get a clear answer, and then 20% were actually able to get the information that they wanted.
So it's pretty hit or miss if you're trying to do it on the phone. All right, and that's just trying to get information from them. Oh, kick me off again. Hold on. There we go. So here's how you do it in writing. Now, a request for information is one of the types of qualified written requests you can send. In this case, a request for information specifically asks the servicer for information about the mortgage loan, such as asking for their loan documents or contact information for the owner, or, you know, it might be a payment history or any other number of things, but those are just the examples. It asks the mortgage servicer for information about the servicing of the mortgage loan. That's the escrow accounting, payment history, things like that. So either information about the loan itself or information about the servicing of the loan. It's pretty wide, or pretty broad options there. The servicers do not have to respond to some things, though. They don't have to respond if it's a duplicative request that's already been answered. So if you ask them the same question you've asked them before and they've already given you an answer, they're not going to respond again. They're not going to respond to requests for confidential, proprietary, or privileged information. So you're not going to get information about their communications with their lawyers or any of their trade secrets or things like that. They don't have to give you information about or anything that's not related to your borrower's account. So they're not going to give you the statistics of what they've done on other borrowers or anything like that. They're not going to give you responses to overbroad or unduly burdensome requests. So if you're asking them for like a book's worth of paperwork, chances are they're not going to get that to you. The requests or if you sent the requests more than a year after that servicer is no longer handling that, either because the loan was paid off or that they sent it on to another servicer, they don't have to respond after that 1 year. So you're going to have to follow up with the current servicer or deal with it sooner. Now, if the servicer chooses not to comply with your request, they do have to notify you in 5 days that they're not going to be responding. Now, when they do receive that request for information, they are expected to conduct a reasonable search for that information. If they find it, they have to provide that information. If they can't find it, they have to provide you with written notification that the information is not available and an explanation of how they reached that determination. And they should also provide you with a contact number for further assistance. That's in case you need to follow up on that. The next category we're going to be talking about is notices of error. So we've got a poll here to see if any of you have ever tried to get an error corrected over the phone. Can we pull up that poll? All right, and your options are pretty much the same as last time. You got it fixed the way you wanted it. You gave up after being on hold too long. The servicer disagreed that it was an error. The servicer promised to fix it, but they didn't. Or you have not tried to do this before. All right, so we'll give you a little bit of time to get those responses. And Susie, if you can just let me know when we've got those in.
We'll do that, and this might be a good time for us to let our viewers and listeners know that in the handout section, in the Go to Meeting box to the right of their screen, we do have 2 samples that Jon has provided to assist you with how to send that notice of error and that written request for information. So if anybody needs to do that, that should be helpful. You can download them right from that section.
Right. Those are so those are just samples. So obviously you're going to want to rewrite them yourself. You're more likely to get a good response from those if they're legible. So I recommend you type them if you can.
Okay, here are the answers to our poll question. And we have 0% say the servicer promised to fix it but didn't. 57% have not tried to dispute an error by calling. 29% the servicer disagreed that it was an error. And 14% got it resolved as they had asked for. And it looks like no one chose gave up after being on hold for too long.
Okay, so it sounds like one person got lucky and got it fixed. That's a good deal.
Yep.
All right. All right, back to our slides. So this is how we do it in writing. Now, a notice of error needs to identify an error that you believe the servicer has made, and it has to be related to the servicing of the mortgage loan. That might include payment issues such as failure to accept a payment or apply a payment or credit your payments properly. It might be escrow issues like disbursement, failure to pay the insurance company or pay your taxes. Or it might be accounting mistakes where they overcharged you on the escrow or something along those lines. Also in this would be where you have to contest force-placed insurance issues. Servicing transfers. Now, when these servicers transfer from one servicer to a next, they have a lot of paperwork that has to, and their computer systems have to get transferred over, and they mess that up a lot. So they might send the improper notices, they might lose your payment accounts or lose record of your payments, any number of things they might mess up. So those are things that are likely to run into problems. Then there's also the loss mitigation issues. Now you can contest as a notice of error their failure to follow the proper procedures or to provide accurate information about loss mitigation, but as we'll talk about in a minute, you can't really contest or appeal them denying the loss mitigation options. Oh, here we are. You can't appeal that denial of a loan modification. And that little asterisk there is to point out that you can do those other things as long as they actually respond. As long as they haven't followed the rules or the notice requirements, you can contest those things. But you can't just appeal the denial. Now, the problems with the origination or underwriting of the loan, none of that applies, because for a notice of error, you're only correcting errors with the servicing. And you also can't use a notice of error about issues of transferring the ownership of the loan, because again, that has nothing to do with the servicers. Now, like the requests for information, servicers can also respond to your requests or to your notices of error if they're duplicative, or if they're overbroad, or if they're sent more than a year after that loan was transferred or discharged. Now, what does the servicer have to do when they get a notice of error? The servicer has to conduct a reasonable investigation to determine whether, in fact, there was an error made. If they agree that there's an error, they have to correct it and notify the borrower that they've corrected it. If they do not agree that there's been an error, they have to notify the borrower that they don't believe there's an error and why they believe that. They also have to include a statement of your right to request documents that they relied on in reaching that decision. And either way, they should also provide you with the contact information if you have more, or if you need further assistance or need to follow up on that response. Definitely, if they decide you don't have an error, you're definitely going to want to see those documents that they're relying on, so you can either take a look and figure out whether or not you still believe there's an error. And if you want to go to a lawyer to fight their refusal to fix it, then the lawyer's going to want to see those documents. So what happens if the servicer doesn't respond at all and they're supposed to? Or they take too long to respond, because those deadlines are pretty strict. Or if they kind of respond to your request, but they don't actually address it head on. Or sometimes, they basically just, refuse to acknowledge that your error is correct. Something along those lines. You have the right to sue for actual damages for failure to comply with the RESPA requirements. You can also get your costs and attorney's fees as part of that lawsuit. Now, if you can show a pattern or practice of non-compliance, you can also get a damages up to $2,000. And those are separate from your actual damages. I do recommend you consult with an attorney. Now, that pattern of non-compliance might be that they're repeatedly not working with you. And so you can set it up as them continually not responding to your problems. Or if you can prove that they do this to everybody, that can also be the pattern or practice of non-compliance. It can be either way. So you're definitely going to want to talk to an attorney to figure out whether you've got a claim here. Now, this is a little bonus. If you want to get a payoff quote, a different law handles that. The Truth in Lending Act is another federal law that describes how servicers have to respond to requests for payoff quotes, among tons and tons of other things that the Truth in Lending Act does. But in this case, a servicer has to respond to a written request for a payoff quote within a reasonable time not to exceed 7 business days. If they cannot respond in 7 business days due to natural disasters or something else going on that slows things down, such as COVID, they still have to respond within a reasonable time. Because this is not under RESPA, that whole provision that says this is free does not apply. They are allowed to charge fees for responding to payoff quotes. And if they do not comply with your request for a payoff quote, you do have the right to sue for higher statutory damages than RESPA allows for, and you don't have to show a pattern of practice in those violations in order to get those statutory damages. So if you believe they're not following the laws on this one, you definitely want to talk to an attorney to see if they can help you with it. All right, and this last slide is just contact information for us as to how to apply for our services if you believe you have a problem and need an attorney. And I guess now is when we have questions. I think I ran through that a bit faster than I expected, so please ask questions.
That's very good information. One of the questions is actually, how do you legally correct a mortgage error from a loan modification that was back in 2013?
All right. Now, that's a little unclear on the question as to whether that's a, the error is the modification being denied, or if they're not following the modification, or for instance, that might be a situation where the loan modification was, you had a loan modification, but it warped in or sort of lumped in a bunch of arrears that you disagreed with, and now you're being charged for those as well. Those are very different situations, but basically in all three of those situations, what you're going to want to do is start with that notice of error to the lender or to the servicer. And you'll explain what exactly you believe the problem is in that notice of error and what they did wrong, and ask them to fix it. Now, just remember that if it's been several years ago, it might not be the same servicer, and the servicer that made the mistake might not be the one responding to the questions. You can still ask them to correct it, even though they're not the ones that made the error. So you definitely still send it to the right, just need to make sure to send it to the correct servicer, the one that's currently servicing your problems or servicing your mortgage. Did we have any other questions?
There's another question asking about any programs that have funds to assist homeowners with mortgages in default. I know there's funding out there right now for helping with rent for people who are in danger of eviction, and actually a moratorium on that. And so I don't know if we have any information about particular programs.
I am not personally familiar with any mortgage assistance programs out there right now. There used to be one several years ago called SC Help, which was wonderful in South Carolina, but they ran out of money and they ended a couple years ago. Currently, if there is any money out there for mortgage assistance, it's going to be in a smaller local program. So your best bet is to ask around at the local charities, or call 211 to see if there's any assistance in your area. You can also check with our local legal aid offices in case any of our local offices is aware of any of those programs.
Can you talk a little bit about, there's a moratorium right now on foreclosures, correct?
There is currently a moratorium on foreclosures in the federal or federally related mortgages. So if you have a Fannie Mae or a Freddie Mac mortgage, or if it's, I don't think those actually, I think it's just the FHA, the USDA, the VA loans. I believe they're currently on moratorium, but the others you can request a forbearance program under the CARES Act, which can get you 180 days of non-payment, or 180 days where you don't have to pay, after which you can usually request some sort of program to avoid having to pay all of that all at once, either a loan modification or a payment plan or something along those lines.
Okay.
All right. Any other questions?
Yeah. So what if the reason that the mortgage servicer gives you for not answering your question is not right, like you think that it's not information that's privileged or proprietary?
Right. Well, that would be I would argue, a violation that you can use to take it to a lawyer and sue them over it. But remember, in order to get those statutory damages, you have to show a pattern or practice. And they're not going to respond a second time because then it's just duplicative. So you're going to have to try and find that information another way. But if you have a lawsuit pending, the lawyer can try and get that information through discovery. So that's certainly an option. But most of the time, if they're not willing to give it, you're basically looking at either trying to get it through a lawsuit, or it depends on how important that document is to you, whether it's worth taking it to a lawyer or not.
Okay, and here is another question. How can you get help with a free attorney to see if you have a claim for your mortgage error? And I think the answer to that is right here on our screen.
Absolutely.
That is to apply for assistance from South Carolina Legal Services. There are other ways, to get a pro bono or volunteer attorney, but most of them start with an application to South Carolina Legal Services. So I think that's all the questions that we have, John. So do you have any parting thoughts before I close out our webcast?
I don't, but thank you for tuning in, and I hope that this information's been helpful.
Well, great. I do want to thank you, John, for a really informative presentation on dealing with mortgage servicers. I think the poll questions that you utilized today really show that this is information that people need, because I think we typically think we can just call and get what we need, but it's clear that from a legal standpoint, it's important to put these things in writing in order to really assert your rights. So I bet our listeners are going to be sending a request for information at the first possible moment now that they know they can do that. Although, yes, some people may have already known it. And hey, look, if you need help with that, folks, just apply for our services as shown here on the screen. And again, this information will be up on our YouTube channel just as soon as our behind the scenes producer, Kenneth, can get it ready for upload for us. Now listen, Level Up Law is a series of free legal events that our lawyers here at South Carolina Legal Services put together for you, the public, so you can get information on some of the most commonly faced legal challenges that we see here at South Carolina Legal Services. So you can join us every Tuesday at noon, just like today. And remember, you can find this and all of the previous Level Up Law webcasts on our YouTube channel. Just go to YouTube and search for SC Legal Services, and you can go to our Level Up Law playlist. And of course, don't hesitate to browse our other playlist offerings that we have there on the YouTube page. And of course, be sure to subscribe to our YouTube page, sign up for notifications, and don't forget, also, we ask you today to please complete the survey that will pop up at the end of the webcast. It's really important to us here at Legal Services to know if we're being helpful in what we're doing. Now look, again, look at the screen. If you have an issue, you need legal assistance and can't afford a lawyer, you may be eligible for our free legal representation. So please do apply. For those who are just on the phone and not seeing the screen, that toll-free number is 1-888-346-5592. Our intake specialists are always standing by between the hours of 9 and 6, Monday through Thursday. And then finally, this is really important, you can also apply online now. And that's at lawhelp.org/sc/online-intake. And on that website, that Law Help website, we have all kinds of legal resources for the public. We don't just have what's on our YouTube channel. We have a lot of great information on that Law Help website. So please be sure and visit that site. Thanks so much, everyone, for tuning in to Level Up Law. And we do hope that you'll tune in again next Tuesday when we'll be talking about tips when applying for our free legal services. So that'll be a really a good one to tune in for, so you know kind of what mistakes to avoid when you're making that application. Another easy way to see what's coming up each week is to check out our legal services webpage at www.sclegal.org, as well as our Facebook page, Twitter, and Instagram. So thanks, everyone. That does conclude today's webinar. Thanks again to Jon Ozolins, and we look forward to having you all back with us next week.